Well, good afternoon, everyone. We're going to wait a couple of minutes to let everybody else load on for this session. So stand by and we'll start at 12. Thanks for joining us. I'm just welcoming all of you that are joining us. We'll give it another minute or so and then we'll get started. Thanks for taking time to join the Lunch and Learn. We'll be with you in a minute. Okay, I'm showing 12 o'clock, so we'll get started. Hi, everybody. I can see some familiar faces out there in our audience. Thanks for joining us today. I'm Scott Zucker. I'm proud to say now the immediate past chair of the dispute resolution section for the State Bar. We've had a great year, and our new chair, Sean Momin's in the audience out there. So it's my last sort of moderator event for the State Bar for our ADR section. So I'm lucky that today I get to introduce the audience to two wonderful speakers on the topic of setting the table for success, improving the odds for productive mediation. And I sought out these guys to speak for us because I've seen at least Tim in action with the Georgia Office of Dispute Resolution, and sort of wowed me in terms of presentation. So I think you guys will be really lucky to hear Tim and John present today. So let me introduce our speakers. First, I'll introduce John Martin. John serves as a senior executive corporate counsel with over 25 years in practice, focusing on global monetization of assets, commercial equipment leasing, and M&A for a Fortune 100 corporation based in Connecticut. Has been a mediator primarily concentrating in domestic relations and an arbitrator for the past 12 years in Georgia and Louisiana. But in addition to practicing law and mediating, John facilitates courses at Cornell University, is an adjunct professor at Johnson University, and serves as the lead mediation trainer in domestic relations at Kennesaw State University Center for Conflict Management. John holds a BA in political science from Louisiana State University, JD from Southern University Law Center, and an MBA with concentrations in finance and enterprise from LSU, and an MS in conflict management from Kennesaw State University. Really happy to have John with us today, and again, talking about his background with Kennesaw State. It was wonderful. It's a great program, and we really are lucky to have it in the state of Georgia. Which leads me to Tim, Dr. Tim Hedin, who also is a professor at Kennesaw State, visiting faculty member at Mitchell Hamlin School of Law, served on the Georgia Commission on Dispute Resolution and the ABA section on Dispute Resolution Council. His research has focused on mediation within and beyond the courts, with emphasis on employment and education sectors, supports constructive conflict engagement as a mediator, ombudsman, facilitator, trainer, and evaluator. and again, an incredible speaker. I've been lucky to hear him. So we're all in for a treat today. I'm going to turn it over to Tim and John. I'll say this, please send any questions that you have for Tim and John in the chat. I'll be monitoring it as they're talking. I may sort of even interrupt them with your questions, but send your questions through the chat, and then we'll save a little time for dialogue at the end. So with that, I'm turning it over to Tim and John. Thanks.
Great. Thanks so much, Scott. Let me check in. John, anything you'd like to say to kick us off, or should I dive into slides?
No, I appreciate the introduction, humbled, but let's dive in.
All right. So welcome, dear colleagues. Thanks for spending your lunchtime or part of your lunchtime with us today. So what John and I prepared is a deck of slides that keep us on track. So I'm going to share a screen so you won't see us so much as you might see some useful information there. Hopefully you see setting the table for success, and there's our contact info. Very glad to continue the conversation beyond today if that's of any interest or use to you. So setting the table for success, I borrowed this graphic from the New York Times, how to host a dinner party. So let's presume mediation has some vague analogy to a dinner party. So I think the bill of goods, which we sold to get you here and with which we'll try to have some fidelity. Did you know that mediators perceive only half of their clients to be fully prepared to make full use of the process? Or that building parties' trust in the mediator can enhance outcomes? Or that parties in mediation can both receive coaching from their mediator and also offer coaching to that mediator? Well, this session will hopefully present insights on preparation for both attorneys and their clients, as well as a practice innovation for experienced mediators to consider. The way we've broken out our time is that John and I are both going to speak on everything. We're vaguely disciplined speakers, frankly, whatever Scott may have told you. But to that end, I'm going to take the first and third as lead. John's going to take the middle as lead. And we again invite your questions at any time. It's going to be Scott's role to sort of identify when those come in and chime in, and we'll figure out when and as we might field them within our presentation. So without further ado, there's our agenda. It's not so much, but we'll be done by 1 p.m. Note, please, that basically our three matters there, the meat of the substance here, the meat on our sandwich, I guess, the filling. We'll speak about dispute and preparation, we'll speak about building trust, and we'll speak about reciprocal coaching. So about preparation, this falls in my bailiwick here. This has been a long an area of my concern and interest. I've been mediating, I worked in a DA's office in upstate New York in the early 90s, coordinating mediation. That's after doing that work on a college campus at the late 80s and early 90s, come to think of it. And I've gone on to work in mediation in a few other states as well. But one of the themes that strikes me across that time has been that we have this wonderful opportunity for this facilitated negotiation to assist parties in understanding their opportunity today to explore possibilities and maybe resolve some of the issues that divide them. And yet, as often as not, they don't come to the table ready to do that, in part because mediation is not a household term, but in part because we don't help it along so often. I'm hoping that many of you already have processes by which you assist clients in preparing for mediation. My observation, having worked with court systems around the country, is that we do various things to try to help folks get ready, whether it's a short video and orientation to the mediation process or a flyer or handout. And I appreciate orientation to understand the process is pretty important. I might also add, though, that preparation to negotiate, preparation or awareness of the need to ride an emotional roller coaster, if the matters at hand are very difficult or poignant or meaningful to the parties, we don't do so much of that. And so that launched some area of interest for me, and I worked alongside a few graduate student colleagues over the years to mount a survey. In fact, hopefully some of you responded to the survey. This has now got to be 5 or 6 years ago. But if you take a moment to reflect on your own experience, you might figure, have you ever seen or looked in your memory banks for a client who came to mediation, either you were representing them or you were in the chair as mediator perhaps, and the client comes to the table just unprepared or underprepared to make good use of the process. that's what gave rise to a research question and some of our work here. So what I find to open broadly, mediators recognize mediation is often novel and unfamiliar to the folks with whom we're going to work. We got those flyers and orientation sessions, but they seem short of the mark. Beyond learning the mediator's role in the process, how might they prepare themselves to negotiate, to ride the emotional roller coaster that at least gets observed in my mediations sometimes, or to make effective decisions and commitments? So these were the questions that animated our work. So we launched a survey. Again, I'm hoping that a handful of you may have participated in this. We got 372 mediators across practice areas to respond to this mediation survey some years back. Again, thanks again if you participated in that. But I'll just summarize the key findings here for us. So the simple question, what percentage of your clients, remember I'm asking mediators, what percentage of your clients, the named parties, not their attorneys or others, arrive at mediation prepared? Fully 53%. Oops, sorry, I'm going the wrong way here. 53% said, yeah, 53% of my clients are prepared. But of course, that leaves the complement. 47% were perceived by mediators to be unprepared or underprepared. 47% practically rounds up to 50%. Half of clients are coming to the table in a way that mediators perceive as being not ready to make full use of this process. So we went on in the survey and asked a little more about, to what extent did you see the most commonly overlooked preparation steps of whatever you think parties might have done to be ready to make use of mediation? What was it they'd overlooked? So number 5, and the list was long. I think we offered 26 different actions you might take to prepare. Why 26? Because we label them with letters of the alphabet. That's why. Anyway, 26 ways parties might prepare to negotiate. And I'll share with you the top 5 that got the most votes as being on that list. Well, the role of the mediator. The 5th most overlooked preparation step was that parties would come not fully appreciating or understanding, what is this mediator doing? Will they be rendering a decision? Will they be offering advice? Will they predict court outcomes? Will they facilitate communication? What's the role? All right. 4th, the party's own interest in the dispute, not their counterpart's interest, but their own. It appeared to our mediators responding to this survey that the 4th most commonly overlooked preparation step was having surfaced or being aware of their own interests. 3rd, knowing the strengths and weaknesses of their counterpart's case, right? So across context, the language of case may not fit ideally, but really, if you look into the negotiation literature, some of which we'll see toward the end of our commentary this hour, there's some pretty strong recommendation that those who negotiate well spend some time in advance of negotiation thinking about their counterparts' interests, positions, alternatives, etc. Right? So not surprising that's commonly overlooked by folks heading into mediation as well. 2nd, the other party's interest in the dispute. The 2nd most commonly overlooked preparation step was to fail, apparent to the mediator at least, to spend some time thinking about what the other party might be seeking. And then lastly, the strengths and weaknesses of their own case. All right, my hunch would be that we lump these together as strengths and weaknesses, but I'm willing to guess that what's behind this is the weaknesses of their own case, that parties may come to mediation not having done a full exploration or accounting of in what areas they don't bring the strongest hand or where they might not find a prevailing outcome, whether it be court or arbitration or otherwise. Moving forward a step, there's a snapshot of the article we published that was in the Journal of Dispute Resolution. The citations will appear at the end of our slides today. So if you're really wanting to read more, we'll get that information for you there. But we also closed that survey by asking, what are the most valuable preparation steps? What would you as mediator wish parties to have done before they arrived at your table? Number 5, that you would consider the other party's interest in the dispute. I note this just showed up on the last list of being in the top 5 of what's commonly overlooked. And here it is in the top 5 of mediators' recommendation unto parties. Spend some time considering the other party's interests. 4th, the ability to make decisions consistent with their goals. Oof. A large proportion of our colleagues place this really high in the top tier here, that parties are coming to the table not fully aware or prepared, having sorted through, what decisions they're going to take that do align with or consistent with their goals. Third, strengths and weaknesses of their own case. By all means, it would make sense that parties should come having known that. Second, their goals for mediation at all. So again, this is the mediator's vantage. Do you understand or do you perceive that the party before you has a full understanding of what their goals might be? And lastly, they should know their interests. Here we are, colleagues, going straight back to getting to yes, but the idea of surfacing, recognizing, working within or toward interests, which allow for some constructive negotiation, tended to be overlooked. So those are the 5 most valuable preparation steps according to 372 mediators who took this survey some time ago. So the good news is that many programs, whether they're mediation providers, whether it's George's Office of Dispute Resolution, others, seek to address this in some ways. One of the ways that I can offer that's relatively new is that up at Kennesaw State, where I'm on faculty, we recently shot a preparation for mediation video that's soon to appear on a GODR website, available at anyone who's heading to mediation in a court-referred process. It's not up just yet. The last I checked with our colleagues at that office, but I can share some screenshots if you want to know what's there. First of all, very handsome actor, apparently sitting in front of the largest law books you've ever seen. And yes, that's a gavel behind us to really confer that mediation's about gavels somehow. At any rate, the important part of the story is that in that video, our presenter speaks about 3 questions to ask prior to mediation. Remember, this is geared towards individuals across contexts. So simple, accessible language was the goal and hope. And the 3 questions that I distilled out of the literature on negotiation and preparing for mediation. Who's in your party? Who's on your team? What about your emotions? Later in the video, I speak about strategies for effective mediation. Again, emphasizing what we learned from the survey. Get clear about interests. Consider the relationship. Reflect on just and fair as being standards that are often invoked, but are always relatively self-defined. Consider appropriate benchmarks to any available outcomes. Know your alternatives before you enter the process. And then last, consider all those 5 things from your counterpart's vantage. So just trying to apply what we had learned through research and what you'll find in much of the negotiation literature out there. That video is available right now at the website that I've got on the screen there. That's just a placeholder. It lives in an account on my account at KSU. I don't think that'll go away. If you want to take note of it, there it is. But that's a 60-minute video trying to speak to this concern or this issue about mediation preparation. I think I've reached my mark. Let me check first. Scott, do we have any questions, comments, concerns about my blitz of mediation preparation?
Not yet, not yet.
Perfect. That's the right number of questions, because now I'm going to turn.
Tim, I think you went on mute, but it's a good lead into to my.
Yeah. Well, it said the host muted me, but I was a co-host, so I don't know what I did to myself. Apologies, colleagues. Let me click forward. John, you go, and then I'll mute myself.
All right, perfect. So I appreciate it. So look, I think that was an absolutely fantastic summation of the need for preparation. And this, what I'm going to speak of next is trust, which goes hand in hand. And I want you to think of this, whether you're a mediator or whether you're an attorney, or if you're like me, a mediator/attorney. I think, being prepared is absolutely critical. Going into it unprepared, just like any other case that we have when you go, the beginning of a trial, I can pretty much look at a crystal ball and tell you with a high degree of certainty what the outcome would be. So when we think of, just a quick 30-second summary, when we think of preparedness, the role of the mediator, what's the expectation? As the mediator, we're a third-party neutral. And, to be prepared and to lay out the expectation to the parties to understand that we're not going to provide advice. We have no skin in the game. We're just here to kind of help navigate, looking at the parties' interests in the dispute, the strength and weaknesses of the other side, the other party's interests in the dispute, and what's the strength and weaknesses of our own case are all critical. Because if we're not prepared, whether it be as a mediator or it be as an attorney representing clients in, before mediation, building trust is going to be absolutely, just very, very difficult. And speaking from the wearing the hat of the mediator, the mediator, the parties come to the mediation if they have attorneys present. They can rely upon the advice of the attorneys. But if they don't have attorneys present, and or if they were not prepared what to expect during mediation, our ability, no matter what we say, to establish trust and help move the needle and help the parties kind of unravel that conflict is going to be incredibly, incredibly difficult. And at the end of the day, to grossly simplify this, it doesn't matter how, well your office looks. It doesn't matter what school you went to. None of that matters whatsoever. If the parties do not have a sense that they can trust you, everything you say is going to go in one ear and out the other. And if that's the case, your likelihood of being able to assist the parties reaching a resolution plummets. And so trust is incredibly important. And to build that trust, and this speaks of trust, but it goes trust as well as confidence. So the mediator, in preparing, presents to the parties that, the mediators laid the groundwork saying, this is my role. And I often use, when I mediate pretty much two large groupings. One, heavy involvement in domestic mediation. So, divorces and custody, et cetera. Then the other polar extreme is where I'm in a conference room with 10 lawyers and it's corporations that we're mediating on some large contract dispute. Those, individuals are highly prepared 99.9% of the time. It's the domestic mediation that I find the parties are not prepared. And so I explained to them that, look, think of this as being, a football game, college football game. I'm an LSU alumni. Think of LSU on one side and UGA on the other. My role is I wear the black and white striped shirt and I run along the field, and all I'm doing is helping you both stay within the boundaries, play by the rules, and not hurt each other and kill each other. Okay. Building that trust at the very beginning is absolutely critical, because that's the message and the buy-in, and more so the willingness of the parties to explore unraveling and unpacking that conflict. Another thing in building trust, I explained to the parties that, look, conflict just is. We all have conflict. It's no different than this coffee cup. Conflict just is. What gives conflict life is the emotions that are attached to it. And by you as the mediator being prepared and being able to earn that trust helps the parties to detach the emotions from that conflict. And if they detach the emotions from the conflict, now you've increased the probability of getting the parties to start thinking clearly, to leave the animosity at the door and to start really objectively looking at this, thinking, okay, we have an opportunity. It's an informal setting. We have an opportunity to chart our own path to a resolution versus, and I know we have at least one judge I saw that's part of this viewing audience, but without a judge or a jury making the decision, which is going to impact our life. And so that's the importance of trust. So we spend the next three slides, and Tim, you can go to the next slide. We spend the next three slides kind of going over trust and just sort of reminding, how do we get to trust? So I can speak all day long on trust. As lawyers, we understand our role as advocates on behalf of the court and trust and ethics, et cetera. And that's fine. But really, let's sort of dummy it down. And how do we really get there? How do we really earn that trust to these parties that we've never met before? Okay. Right here on the left-hand side, trust building factors. This is critical, and it's critical. And I think this is important to simplify it. And when I do the teachings of conflict, and definitely when I hold conflict session or mediation sessions, I'm aware of each one of these because, it's often easy to overlook. But factors such as the mediator's credibility and reputation, that's incredibly important. If, the parties to a mediation have a right to know, am I properly trained? Am I registered? Do I have whatever requirements need to be satisfied? They have the right to know that. I often get asked that as a fresh mediator who just got, trained and they registered with GODR or registered with the Louisiana Bar, do they have to let the parties know that, I'm happy to mediate. This is great. This is going to be a first-time experience for me. The answer to that is yes, you got to let them know. Okay, we can, just like lawyers, we can't hold anything back, nor can we hold ourselves out as being something that we're not. But, if the party's asking, and I can tell you, I've been mediating for over 12 years, and I've never had a party ask that, but keep that in the back of your mind, building that trust, that presentation. If I came in with a t-shirt that said, AC/DC, and I'm ready to mediate, let's get started. That perception right there, I don't even need to open my mouth. It's already going to raise questions to the parties like, kind of mediator do we have? So it's your presentation. Okay, it's how you begin with your introduction, et cetera, explaining what is the process of mediation. Another thing that builds trust is the mediator's experience in the type of dispute. Like I said, I'm trained in all categories with GODR. I'm trained in everything that the Louisiana bar offers. I mediate all throughout Southeast US for that fact. But the two main buckets that I mediate in is domestic relations, unfortunately, domestic violence added to that, and then the corporate world, large scale disputes dealing with transfer of assets, et cetera. But if somebody came to me, even though I'm a licensed attorney and I know probate and all this, and if it said, we'd like to mediate a probate matter, I'd be like, not me, because I'm not well versed in it. We have an ethical responsibility as much as we do as lawyers. If you're assuming the role as the mediator, you have an ethical responsibility to be able to provide competent service of helping the parties unravel. And if it's an area that we're unfamiliar with, just like with law, then you need to pass that on, refer them to another mediator. But think about it, if I was to mediate a situation that regards Uniform Code of Military Justice, for example, I am a veteran, but I couldn't tell you anything about it today. So my competence is going to come out in bold letters with neon lights showing that I don't know what I'm talking about. So be aware of what's the type of dispute that, you're going to mediate, and make sure you're competent and you feel comfortable in that. Next, the mediator's procedural experience. This goes back to when I think of, at the introduction, what's your role of the mediation as the mediator? What can the parties expect during mediation? Remember, they've got a conflict. It's laden with more emotions than we can think of. They're under pressure. If they've hired lawyers, they've got the added expense. They've got the formality of the court system. And now they're going to this thing called mediation. And they're thinking, okay, this is going to be just like everything else where it's like really formal, yes, your honor, blah, blah, all this. It's an informal setting. What I remind the parties all throughout is like, look, we're here just to explore and see if it's possible to go ahead and come to a resolution. My job is to help you guys unpack that conflict. But keep in mind, it's an informal setting and it's confidential. And so the court's not going to require you to come to a resolution, but they're giving us the opportunity in an informal setting to let's just explore. And if we come to a resolution, it's going to be based on what you guys decide through self-determination. And so, that to me goes back into the procedural aspect of explaining to the parties what is mediation so they can be comfortable with it. That builds trust in the mediator. I tell you from the very beginning, and I'll tell you all the way through, if the parties do not trust the mediator, your likelihood of being able to be effective on assisting the parties to come to a resolution is about the likelihood you have of translating a 40-page agreement that's written in Mandarin Chinese. It's incredibly, incredibly unlikely. Okay. So, again, the parties have to believe in you that you have a willingness to help them unpack and remove these emotions, separating the people from the problem. Okay. That's incredibly important. Again, impartiality, as the introduction, one of our roles is to look at the parties and say, have I represented either one of you, whether it be in the capacity of a lawyer or in a prior mediation? What you want to instill in these parties is that, look, genuinely, you just met me. Okay. But neither one of you I've met before. We're not related, anything of that nature. There's no vested interest that I have in this other than a genuine 300% vested interest to help you both separate the emotions from this. Let's explore different options. And those of you who have been mediating for a while, you've heard terms like, let's split the pie. In in addition to let's expand the pie. We're professionals and we're trained in this, so we have the ability through different tools and maneuvering of the parties to get them to start thinking beyond what they thought of before they walked in here. So remaining impartial is a way of building trust as well. The last is goodwill and empathy. Okay, this goes back to us as mediators being active listeners, really being attuned to what the parties have to say. Remember, we can't ignore the fact that they're under a tremendous amount of emotional stress, financial stress, you name it, anything and everything, that they could be feeling, and they're in desperate need of help. And that's why I passionately love being an attorney. I passionately love being a mediator, because it allows me to not be an active participant, but to truly help these parties explore a possibility of a brighter future, of a new beginning, writing a new chapter, that before they came into mediation, all they saw was dark clouds. They couldn't envision this being unraveled. And what do you mean? We have the ability to actually end this ourselves? That builds trust. Your body language as a mediator. Okay, if you're not establishing body language, the tone of your voice, how your delivery, how you're trying to elicit information, if you're constantly interrupting the parties, okay, that is not going to build trust at all. Again, this goes back to, and I know this is grossly simplifying things in one hand, but the same hand, I cannot overemphasize the need for preparedness, the need to intentionally build trust. Okay, those are critical, because those are going to directly impact the likelihood of a favorable resolution for the parties. The next slide. And that's hence the reason why we're kind of going through this as a reminder, but also to open up, because look, I learned from you guys as much as you guys learned from Tim and I. And so we'd love to hear what are you experiencing in the field? What could be an issue that's presenting, obstacles on whether it be preparing or, building trust, et cetera. So going a little bit in deeper dive in this idea of, how do we build trust? Goodwill and empathy. I just mentioned that, that's important for the parties to feel like, what, I'm listening to the mediator, but I don't think the mediator really cares, because he's constantly looking at his watch like, ooh, it's about lunchtime. You're going to be sending the wrong message absolutely 100% of the time, all the time. So coming across with that genuineness, that sincerity, that, willingness to say, what, I do not cast judgment whatsoever. Okay. I'm here to help you guys understand could be the root drivers that's creating this conflict, and how can we unpack this? So, coming across with that willingness to help is important. Credibility and reputation, we already addressed that. Chemistry, if, when I'm dealing with domestic mediations, oftentimes, especially when there's domestic violence involved, it's not uncommon to have the lawyers present, and which is fine. I welcome that. But if a lawyer is constantly interjecting and serving as the mouthpiece, which we're all hired mouthpieces for our clients, but in a mediated session, the rules kind of change a little bit, because it's not directed and owned by the mediator, nor is it directed and owned by the lawyers. They're there to advise. It's the parties themselves who own this. But in that aspect of chemistry, I've seen this happen, unfortunately. I've seen a mediator get into an argument with an attorney that represented a client. And that just, you can imagine how that set the tone for the entire mediation. And so, be aware of the chemistry, be aware of that, not only between the mediator and the attorneys, or the mediator and a party. Remember, we are impartial. And as I took an oath to the bar, same thing. I take an oath to my ethical belief in mediation that, I'm going to be impartial. I don't side with a party. I don't cast judgment. I make sure that I give the same degree of empathy, the same degree of respect to each party, because I want to make sure that chemistry is there, that open and willingness for that party to explain to me what really is driving them, what really is important to them. So chemistry, mastery, going back to, understanding the dispute. I got a master's in addition to being a lawyer, et cetera. I went back because I'm so passionate about this. I was underneath Dr. Hadeen, who was my instructor on several classes, you know, learning the art of mediation. You don't need to get a degree for it, though. There's countless superb books from Bill Urey and others that are out in the field, as well as subsections like this with the Georgia Bar, to really understand what tools are available to me to become a more effective mediator. GODR, I spend half my time, on GODR's website because I'm always looking for little tidbits, little nuggets to improve myself, and a great, phenomenal resource to get, more familiar with the different aspects of mediation. But, to really understand the dispute, this goes full circle back to preparedness. You've got to prepare. Every single mediation that I do, whether it be big or small, because to me, they're all the same, by the way. I prepare. I want to understand, and I'll have my legal pad and I'll have column A and column B. And I try to understand and predict what's most important to this party versus what's most important to that party. And I try to envision what could be some scenarios, what could be some trade-offs. All of this being prepared, allows you to better understand the dispute itself. If you sit there and half the time you're scratching your head, like, I don't understand, you've lost the idea of instilling trust and maintaining trust throughout. So, truly understand what the dispute is and help prepare the parties before the actual commencement of mediation. Understand and explore and think outside of the box. As a mediator, it's best practice to engage with the parties, at least to say, please provide me with certain documentation. Why don't you summarize party A, what you feel the root drivers of this dispute is, and then I'll go to party B, the same communication back to them. Why don't you explain to me what the root causes are? And I'm trying to put the pieces together so I can understand what's sort of the root driver that I can anticipate. Understanding the dispute before we begin is important for me, but it also invites the parties themselves as they're preparing for mediation. What's important to you? What do you think is important to the other side? As Tim illustrated, it's shocking the percentage of the respondents said that, well, the parties really don't know why they're really mediating, or they haven't given much thought of what's some sort of potential trade-offs or solutions to come to. And for them to come to the table at that point means we're not only starting at ground zero, but actually we're starting negative to that, because you've got to bring them up to speed of having that openness of like, okay, well, this is a great environment right here. Let's throw everything on the table. And like the beginning of this says, how do we prepare the meal? How do we prepare the dinner? Preparation is important. It builds trust, and it allows the parties from the very beginning of the mediation session to really start having some constructive dialogue. Next slide, Tim. I was going to say that looked familiar. Okay, warmth and consideration, that, goes back to the body language that we have. Active listening, that's critical. Active listening is critical in multiple fronts, because one, it allows us as the mediator to really read between the lines, to really understand what's a pain point for this party versus that party. And as we're hearing all of this from both parties, what's critical to them versus could be a concession that they can make, it allows us to start thinking, again, how can we expand that pie? How can we help these parties think beyond what they may think is the limits of their capabilities and what they can agree to? So becoming an active listener is incredibly important for us, but it's equally important for them. It lets them realize that, what, I hear you. And I say that, and it sounds like, okay, well, of course they hear you. You're speaking, they hear you. But you've got to remember, we don't know what these parties have experienced before they came to your office for mediation that day. That opportunity for them to sit in mediation, and I see this often in domestic violence, it could be the first time that that party feels empowered to say what's really bothering them. Okay, that's what active listening allows us to do. Okay, it conveys to that party, to both parties, that, what you have to say matters to me. Okay, and I'm passionate about wanting to help you reach a resolution. Again, something that through self-determination that you both think is fair, that you both think that you can live with, because as you're writing the new chapter in the next stage of your life, you're going to have to live by this. And so rather than a judge or a jury making that decision for you, I hear you and I want to help you navigate through this. Okay. Next one, mediation principles. Again, this goes back to, we are truly, and the GODR, the Georgia bar, the Louisiana bar. In fact, I'm positive all 50 states have the same standard. A mediator, okay, is a neutral. There's different types of alternative dispute resolution, et cetera. We're not arbitrators, okay? We have no vested interest in this. We are the neutral, meaning I'm the third party. I'm the referee wearing black and white striped shirts. I don't care if LSU wins. I don't care if, University of Georgia wins. What I do care about is the integrity of the mediation is upheld. I'm passionate about truly wanting the mediation session itself to be as effective as possible. As a lawyer, and each one of us as lawyers, look, part of our DNA, and just from the nature of our profession, we're winners. We're competitive. We want to win. Okay. As a mediator, when I take off that lawyer hat, I find that there's still that part of my DNA that I can't just cut out of me and put aside. I want to see a favorable resolution to these two hurting parties. Okay. I really, really inside of me want to see a favorable outcome that they feel is favorable, not an outcome that I think is good and just, but something that they feel is good and just. So I'm passionate of wanting to help the parties unturn or flip over every single stone, even stones that they might not even be aware of. Okay. That's important. But in doing that, I still need to maintain that neutrality. So establishing the neutrality, not showing favoritism one side or the other. And some of the mediations in the domestic violence world, I've heard things that I had to make sure that my facial expression just remained the same versus holy smokes. That never happened. I kept my composure because, again, it's the body language that we as the mediator portray to these parties. And I've heard anything and everything, as I'm sure some of you and many of you may have, but keeping that composure, keeping that professionalism, that all supports that overall notion of trust. And then going back to the last, explaining the mediation process itself, look, we have to do that at the very beginning. It makes sense to do that, but it's a requirement that we do that because, again, we're educating the parties that this is what you can expect. This is what you can expect from me, and this is what I expect from you. I expect respect. I expect decorum. I expect that we go into this with good faith, et cetera. But in return, what you can expect from me is not casting judgment. I cannot give you legal advice, financial advice, et cetera. And, another advantage of mediation is the confidentiality of this. And I stress that all throughout. That, this is an opportunity for us to go ahead and let all the skeletons out of the closet in a closed room, similar to what goes on in Vegas, stays in Vegas. What goes on in the mediation session stays in the mediation session, but for the exceptions, which is, harm or abuse to children or harm or abuse to others. Other than those few exceptions, which I make clear, I let them know that, look, this is a perfect opportunity for us to go ahead and explore potential opportunities to come to resolution. And that when we're done with mediation, I shred my notes and I stress to them that, if I'm subpoenaed to court, a motion to quash will be filed. Unfortunately, you'll have to pay my attorney's fees for that. But I want them to understand that, this is the rules of the game. This is my part in the game. And this is what you can expect in this. And it all supports the notion to build that trust, to get them to open, their mind to the possibility that there could be a resolution that they may not have explored or considered before. And so, Tim, next slide. I think we may have reached.
We reached a point of transition. And in fact, I think this stacks up beautifully because this goes on to explaining the process. So, dear colleagues, in the interest of time, we're going to pivot onto this. This comes from an article by Magistrate Wayne Brazil. You may know Wayne's name. He sat on the Northern District of California Federal Court bench for a long time. Very influential thinker as well as practitioner in dispute resolution. So I highly commend you this 2014 article I note it's 10 years old, and yet I'm still shocked when I go around the country training CLEs, the number of colleagues in the mediation profession who hadn't come across it. Makes a lot of sense. There are a lot of things to read, almost too many, right? And so in case you hadn't come across this, I bring it to your attention today, but I'll summarize the key parts as far as I can tell. So let's note the title of the article, Reciprocal Coaching to Reduce the Risk of False Failure Mediation, and Support from Social Science for Coaching Ideas. So couple quick things to note, and I really admire Wayne's phrasing of these as well. He opens with a couple prefatory clarifications. One, this essay addresses mediations in civil cases, one, in which all parties are represented by counsel, two, that will not need to surmount any further challenges to get to trial. Second, some of the coaching ideas described could be discussed in joint session, while others will be presented only in caucus. Third, while many ideas arise from social science research on integrative negotiation contexts, these may work when only distributive outcomes are available. So you'll note some of that, I think, gives you a sense of Wayne's affability and humility in making this presentation. I'm going to wind down my comments just a couple slides time by actually showing you Wayne printed his entire, or the relevant parts of his opening statement as a mediator. And we're going to harken back to some of the points that John raised about being perhaps a referee or otherwise, thinking of mediation within a sports analogy. Sometimes sports analogies may be overused, but humor us for a moment, if you will, here. But let me go forward with what Wayne's offering here. So the way he sets up his articles, he says, look, there are mediators and there's the clients and attorneys, and I'm going to offer that I'll offer to coach them in one direction. And things that are going to guide my role of using coaching skills would be process, not content or substance. I'm not going to evaluate their offers or tell them what's right or wrong or otherwise. I may offer them coaching on how to make best use of this process. Secondly, I'm going to try to raise their awareness of cognitive biases or ethically ambiguous negotiation tactics, which he abbreviates EANTS. This comes out of some earlier research by Vidmar and Rackham, but I'll cover those on the next slide actually a little bit. And third, I might offer them tips based on successful negotiators. What have we seen? What do we know about how negotiators comport themselves that tend to lead to positive, constructive outcomes? So those are the types of things which I, as mediator, might offer in a coaching mode toward my clients or the attorneys involved. Now, vice versa, though, the reciprocal part of this comes into play in the other direction. He invites clients or attorneys any suggestions they might offer him on how the mediator might play a more constructive role. And he also invites their thoughts and ideas on altering or improving the mediation process. And this, dear colleagues, is the part that I find perhaps most a stretch or unfamiliar to many of the experienced mediators to whom I bring this article or who want to share and speak about it. When I was in a mediator study group and we would talk about articles, every 6 months or so, as well as challenging cases we had been part of, I recall the first time I came across this article, and we had discussion about it, though, and there was at least one colleague for whom this felt very foreign and very unfamiliar to the point of uncomfortable. The idea that you would show humility or affability before parties, that they might tell you how to improve the mediation process, struck her as being inconsistent with her mode. And so you'll have to consider for yourself whether this might fit or might work with your own style or with the clients whom you serve. But let me just round out here responsibly those asterisks. Ethically ambiguous negotiation tactics, which is also, by the way, a pretty fun exercise or role. We have a number of different instruments we might use in classrooms or in training spaces where you ask attorneys about, is this okay? Is that okay? And you try to figure out when you might cross the line. When are things no longer ethically ambiguous, but unethical as negotiation tactics? And then tips based on successful negotiators are what's coming forth here on the next slide. So let me move us through the slides and I'll invite your questions in just a moment's time. So here are 4 tips that that Wayne reprises within his within the article that move from Neil Rackham's work on negotiators. So the first one, with which you may already be familiar, is to move freely among issues without insisting on addressing them in a particular sequence, without forcing linkages between them. Right. If you'll recall, if Rackham's research is new to you, Rackham basically asked the community of labor negotiators in the UK, and later this was recreated in the US, if I recall. You work in a small system. There are about 40 of you who all do negotiations with or against one another, across time. Who are the best 5? And so he took that sample and he said, what distinguishes these 4 or 5 folks who were routinely named as being the most sophisticated or savvy or effective negotiators in our community? What do they do that's different from what the other 46 of us do? All right. So moving freely among issues was on that list. Secondly, ask more questions than you might otherwise be inclined to ask, and frame them as openly as possible. So they're real questions, not just poorly disguised arguments. So be mindful to your colleagues. This is advice for negotiators to negotiate effectively. And these are the types of elements that Wayne might counsel someone, perhaps in caucus, I'm guessing for these, to think about how they're handling or maneuvering within the negotiation, within the mediation process. Third, test your understanding more often than you think you might be inclined, either through asking questions or by offering short summaries of your perception of the status of negotiations. Right? And this idea to test understanding, to make sure that everyone's on board or at the same place in the negotiation, sharing understandings, can be useful. Lastly, avoid gratuitous irritator comments. So positive characterizations of the speaker's own acts or proposals, our generous offer, or our or your fair or reasonable proposal. Right, it's found in research that those sort of modifiers are seen to be not only trite, but actually perhaps somehow deleterious to building trust and relationships within negotiation or within mediation. So those are among the insights that Wayne supported as or illustrated, being what he might coach clients with. Let me move on, though. I have 3 quick slides here with which I'm going to recount Wayne's opening statement, and I've highlighted some elements of them. Forgive the small text. In some, I'd like to suggest what I think is a useful way to conceptualize the goal of this mediation. Our primary goal is not to settle your case. Instead, our primary goal is to identify as reliably as possible what is possible through this process. What we want to do is identify the best terms are accessible through negotiation. Only if we succeed in accurately identifying those terms, we will position each of you to compare rationally your alternative paths forward, agreeing to settlement or proceeding to trial. Once we've identified what's possible through mediation, it will be up to each of you to decide independently whether to end this case by mutual agreement or proceed with the litigation. To maximize the odds we will achieve our goal, it is essential that everyone who participates today share responsibility for the productivity of our process. As we move through the day, each of you will be thinking about your positions, your interests, the relevant law and evidence, but we also need you to be thinking about the process itself. At each juncture, what would be healthiest for the process? What seem to be the principal barriers to getting a deal? How might we best work to overcome those barriers? Are there ways we could proceed that would increase our chances of success? Should we change formats? Should the parties meet without their lawyers? Should only the experts meet with a mediator? Should we shift our attention to a different subject or a different possible component of a deal? How is the other party likely to react to or interpret a contemplated proposal or move? Are there additional people we should involve? Is there additional information we should share or for which we should ask? In sum, we need to keep asking ourselves how we should shape or adjust our process so as to improve the likelihood that we will learn as accurately as possible what is possible. We have a much better chance of succeeding in this if all of our minds are thinking about these things than if it is only my mind that focuses on what's best for the process. We will have a better mediation if we think of mediation as a team sport. But it is a team sport with an unusual feature. Every participant is simultaneously a player and a coach. One of my jobs is to offer coaching suggestions as we move through the day. For example, I might make observations based on my experience about how the other parties are likely to understand or respond to some move or idea that's being considered. I would like all of you to play the same role, coach me, Suggest ways I might play the most constructive role. If you have an idea about how we might best proceed, tell me about it. We can consider it together. If it would make you more comfortable, pull me aside so we can think about your idea privately before we plunge ahead. Several years ago, it occurred to me that one way to understand a primary objective of my coaching during mediations is to help reduce the risk of false failure. False failure occurs when, in theory, there are terms somewhere out there on which parties could agree, but we fail to find those terms because we make some unnecessary, avoidable process mistake. The kinds of mistakes I'm talking about include posturing too much or for too long, playing informational cards too close to the vest, interpersonal or psychological errors, for example, saying something that needlessly offends another party, or taking positions that leave other participants too little room to achieve something, failing to see that shifting to some other format or having principals or experts tossed directly to another would create new opportunities or would better meet certain needs, sending misleading signals or misreading signals that others send, or falling victim to a common cognitive trap like reactive devaluation or confirmation bias. And he closes. As we proceed through the mediation today, let's keep these potential sources of false failure in mind. Each of us should be on the lookout for them. Each of us should help us avoid them. In other words, let's coach one another about how to handle the process most productively. Let me stop sharing for a moment there before I show you my last slide, which is just the citations. Dear colleagues, I would invite your questions, comments, responses to that idea or anything we've spoken of so far. We've got about 5 minutes on the timer. I'll open the floor, or Scott, if you want to open the floor. Colleagues, if you have a comment, question, concern, feel free to step up to the mic or raise your Zoom hand.
Well, Tim and John, thank you. Yeah, there looks like there are some questions out there. They're not putting in the chat, but I see Larry waving his hand. So go ahead, Larry.
Tim, I want to harken back to the 5 points that you said where people are underprepared for
Yep.
mediation. Unlike some of the mediations that you and John talked about, I do just business mediation, and way too often it's just about money. It's not about who's going to get the kid and what are we going to do with the asset and things like that.
Sure.
A lot of us, if not all of us, sometimes have a pre-mediation conference with the lawyers to try to understand some background we need to know going in. Seems to me that those points that you raise might be something not to wait until the night before to raise, but to raise it several days in advance, if not even in our engagement letter, like a little thing about before you approach mediation, make sure that your client understands and is prepared to discuss the following 5 points. Because when we go into reality testing, you can catch parties off guard, which is sometimes the goal. But too often people don't understand what the other side's position is or what their own weaknesses are. And then you sit there sometimes for an hour and a half in a caucus or in between a caucus while they start to talk about it. So I just wanted to, it's not really a question, more of an observation, but I really appreciate you putting those points up.
Okay.
Because it really drove the point home that that's something I think the parties themselves need to understand long before they walk into the mediation rooms.
And
As an atheist, I'll say amen. But I'd also add quickly. So I appreciate and think you're spot on. If you can include that in the engagement letter and in the phone call pre-mediation or whatever consultation you have with counsel or others, I think it can't hurt at all, right? So I'm all for it, and I think it expedites. It makes better use of the process when people are in the room on the clock and otherwise. If they've come prepared, I think things tend to go better. So yeah, I fully agree. John, it sounded like you had a comment to pick up as well.
I was just going to simply elaborate. Larry, you're spot on. I like I said, I do domestic relations mediation, and the other polar extreme is business mediation, where it's millions of dollars in dispute. There's multiple lawyers that are involved, each one of them getting paid more money than the government prints. We do hold pre-mediation sessions. And not only one, sometimes depending on the complexity, could be 2, 3, leading up to mediation. And that's critical, because what we're trying to do is get the parties to really understand how far are we literally on 2 different sides of the ocean, or is there somewhere in between that maybe we're closer than we think? And let's focus on, number one, identifying where there could be common interest that may have never been communicated across the aisle. So where's there's common interest, and what are the true sticking points that we need to focus our attention on? So
Yeah,
no, great point to
And
raise.
not to dominate the time, but we also deal with the claim counterclaim situation where there's a zero in the middle. Somebody needs to be walking into that mediation prepared to cross that line or at least meet at it. Otherwise, you can't settle the case.
No, absolutely. Great point.
Yeah. Thank you for your time, both of you.
Yeah, certainly. So I see in the Q&A, someone picked up a question on what if you have a viable motion to dismiss pending, mediation has been mandated prior to motion to dismiss being reviewed and ruled on by the judge, if your client's the wrong party being joined to the case. Yeah, this is a sticky one. You know, one of the guidelines in the states that I've consulted with courts around when and how to institute mediation would be that we've survived all those challenges. And yet I appreciate sometimes you get thrust at an intersection. So I'm going to punt to my attorneys on the panel to answer that question then. John, Scott, what do you do with this?
I'm going to let Scott answer that one first.
Oh, there we go. Yeah.
Oh, that's really unfair.
Speak up first, so I'm going to let him hold it.
No, I'm not an expert on this, but to the extent that I think all those, just like Larry was saying, that all these issues have to be on the table for discussion. I mean, the mediator is not resolving any of this, but they have to be aware of the pending issues. As you guys listed on your elements there, to be aware of these claims on both sides is really important for the mediator to be aware of what they're walking into. Always troubled when I find a mediator that hasn't even studied the case before we start the day.
Yeah.
It's always a waste of time. I like mediators that start ahead of time, know what they're getting themselves into. But let me flip to the last question that I've been asked about neutrality for a mediator, to get your input on this before we close. There's a lot of folks here that are mediators that do a lot of mediation and work with the same lawyers many times and build a reputation for doing a good job as a mediator. Does that play into the neutrality for counsel or parties that are not familiar with the mediator? How do you handle disclosures? How do you handle the reality that there are mediators that are commonly used in our community?
I'll go first only because I was on the commission for 7 years. I somehow didn't get off in the standard cycle. Extended sentence, I guess we call that. So my recollection would be that's disclosure that's done up front, and it's the mediator's role to engender as much trust as you can to say, I have certainly worked with Counselor Martin in mediation before, and I need everyone to know that that relationship doesn't constitute any way or influence my impartiality here today. And if you have concerns, let's surface and talk through those before we begin. Right? The invitation to clarify those, I think, is required. The disclosure, I think it's required or highly recommended. But at least for me, in the mediation context in which I work, I'm not trying to being quick to disqualify myself, but I do want to make sure I don't give a reason for a party to sit through mediation for 2 hours, decide they don't like what's come forth, and then blame me for the fact that, oh, Tim's meeting with Zucker in the room, 5 or 6 times I found out now. They were in the bag the whole time. So I at least err on the side of heavy disclosure and invitation for parties to critique, register any concerns they have, and we have to resolve those before we start. That's at least my approach. John, you want to correct that at all? Or?
Absolutely spot on. Same approach I take. Again, this goes back to building trust. And I don't want anything not to be disclosed at the very beginning, because if they learn about it, and they often will, if they learn about it after the fact or midway through, there goes trust, there goes the integrity of the mediation process itself. And I stress the part that by me laying it out there, by me recognizing that Dr. Hadeen and I, who's an attorney, I've mediated for him before in the past, it instills that openness. So I let it out from the very beginning.
Sorry, I just had to get that citation up there because I promised it earlier. Apologies, John.
No, you're good. You're good.
So I want everyone to be aware that a lot of materials were provided by John and Tim as part of the CLE content. And Tim, can I check, was the information from Wayne, that outline provided with the CLE materials? That's what I thought. So anyone can look at that. And certainly I'm sure Tim and John are available, follow-up questions. We've reached the end of our hour. I want to thank especially Tim and John for participating and leading us through this discussion today, and all of you for taking the time to participate in another State Bar Lunch and Learn program. Look forward to seeing you guys at the next program, and look forward to having you guys hear from Sean about the scheduled activities for the ADR section for the State Bar. We have a lot planned for the year coming up, and in the interim, everyone have a great summer, and thank you for participating today. Thanks, everybody.
Thank you, everyone.
Thank you, colleagues.
All right, take care.
Hey, all right.